I'm going to talk about the organisation of police forces and briefly duties to officers. We'll discuss the specific scenarios and questions later. But the issue here is that the police might need to be deployed quite rapidly in different areas of the country. One's seen, for instance, in Italy and in France. There have been specific areas that have required particular policing and requirements, policing personnel. And that may become the case within England and Wales. And so the first consideration is just an overview of collaboration agreements and potentially collaboration agreements as opposed to mutual aid. In relation to collaboration agreements first, you'll want to consider, if there is to be a collaboration agreement, to whom direction and control will pass. You are permitted under collaboration agreements to transfer direction and control under section 22A to 24 of the Police Reform and Social Responsibility Act 2011. So a situation you could potentially have is one host force and perhaps two or three smaller satellite forces, and a collaboration agreement could transfer direction and control from those supplying forces to the host force. That host force could then lend those officers back to those home forces, but be able to redeploy them at short notice whenever that was required. The identity of direction and control, however, will be important, because if it does transfer to the host force, then the host force will become the appropriate authority with respect to misconduct matters, complaints. It will have the responsibility to comply with health and safety requirements, provision of protective equipment, which may be of particular importance given the matters now, and matters of training. That means, for instance, that if a host force lends a home force officer back to the home force, they could end up being paid differential rates, use different equipment, and if a complaint were made against them, then the appropriate authority would be the host force and not the home force. And similarly, where officers acted unlawfully, then liability for that would follow the line of direction and control. That is, of course, a different issue to command and control. As I said, the host chief constable may delegate the command and control of officers back to their home forces for them to perform policing in their home force unless they're required to be deployed somewhere else and at short notice. Where they do delegate command and control back to the home force, then of course the home force acts with a delegated authority of the chief of the host force. That being in a collaboration agreement is very different from mutual aid, and careful consideration will have to be given by police forces in the coming weeks and months as to which one is appropriate. Mutual aid is where a chief constable provides constables or other assistance to another force. That's considered to be only a short-term measure, and it's for the purpose of enabling the force to meet what's determined or what's described as special demand on its resources. Where officers are provided by mutual aid, then the direction and control transfers to the receiving force. All your police forces should have a strategic policing requirement, which is to deal with, amongst other things, public disorder and civil contingencies. Chief officers must have regard to their strategic policing requirement, and the police and crime commissioners will potentially hold them to account in respect of it and their following of it. The things to be aware of when considering potential for collaboration agreements or mutual aid is that mutual aid is considered to be a short-term measure, and it's a short-term measure to cope with special demand. Special demand is a state of affairs that lasts for a relatively short period of time. By comparison, a collaboration agreement can continue for a much longer period, potentially months, potentially indefinitely, depending on the nature of the agreement. Mutual aid involves the payment of an agreed contribution between the two forces. It doesn't work in quite the same way with a collaboration agreement. So, just by way of example, if there were a particular public order issue, for instance, riots became localized in a particular area of England, then that may amount to special demand, and mutual aid might be appropriate. Whereas a collaboration agreement, however, could be used to allow collaboration for any policing activity or any policing function, even if not immediately urgent, and even if not amounting to special demand. The purpose of collaboration agreements is that mutual aid should then be unnecessary. They can, of course, still be used at the same time, but mutual aid shouldn't be used as a substitute for a collaboration agreement. Historically, it used to be that on a collaboration agreement, direction and control couldn't pass from one force to another, such that mutual aid was more attractive. But now, for some years, direction and control does pass in a collaboration agreement, although the collaboration agreement itself must specify if direction and control passes and to whom and in what circumstances. It's also worth bearing in mind that police collaboration is not merely a choice for chief constables, it's a statutory duty. That's in sections 22b and 22c. Chief officers are required, as a matter of law, as a matter of statute, to keep collaboration under review, and where they consider that it's the best option, they must then collaborate. As to it being the best option, that doesn't mean the best option for their particular force. If the chief officer considers it's in the interests of another force, then they should consider whether the duty to enter into a collaboration agreement then arises. That deals with the way in which police forces may wish to organise themselves, both in relation to collaboration agreements and mutual aid. And careful consideration should be given to it, particularly in circumstances where there may be, as I've said, particular policing requirements in particular parts of the country at specified times. The second issue is the extent to which police forces may wish to try and increase their numbers, either police constables or in relation to police staff who may have similar powers to constables. The Police Reform Act now provides for civilian officers to be appointed as either community support officers or policing support officers. A policing support officer may be designated as having any of the powers and all powers of a constable, save specified matters, specified powers. The powers that they may not exercise and may not be designated to exercise are a power of arrest, a power of stop and search, whether of persons, vehicles or things, the performance of functions of a custody officer, the power to conduct an intimate search, powers that are exercisable only by officers of specified rank, terrorism or counter-terrorism powers, or the power to make applications for RIPA warrants. The relevant provisions for this are in Section 38 of the Police Reform Act. Police staff may be designated as either community support officers or policing support officers only where they are suitable and capable to carry out these functions and where they've received adequate training for them. Similarly, the police may appoint police volunteers as a community support volunteer or a policing support volunteer with the same powers. It would appear from the wording of the legislation that a person must be an employee before the designation is conferred. So a force might, in the interim, in the periods coming up, might seek to hire new persons as dedicated police support officers, but they can't be slotted straight into the role. They must first be a member of police staff, and then they must have had the adequate training. The designation should not be given until they have had adequate training. You may consider that ex-officers, former officers, however, have had sufficient training to be able to perform substantially all of the duties that may be imposed upon them if they were to be rehired and designated as police support officers. However, they may at least require some additional training on the limitations of their powers and the limitations of their powers in relation to the duties that they may be required to perform before they are designated as police support officers. When a chief constable does designate a member of civilian staff, a police staff member, as a police support officer, the designation must state what are the person's powers and duties, and the ability of the officers to act pursuant to those powers is limited to the duties conferred upon them. If the civilian officers are to exercise their powers outside of their force area, then that must be stated in the designation. You'll be aware that chief constables have a territorial jurisdiction all across England and Wales. Police support officers do not have such jurisdiction. They are limited to their own constabulary. And so if it is intended that police support officers exercise powers for their home force in an area which is outside of the constabulary, then that needs to be stated within the designation. To be clear, it's not a legal requirement for a chief constable to notify the chief of a neighbouring force when either officers or police staff exercise functions for that force, that home force, in another constabulary's area, although it is certainly good practice for them to do so. That is somewhat different to the transfer of civilian officers by way of a collaboration agreement. A collaboration agreement can provide that civilian staff have the host constable's powers when they are given to the host force, and that is where they exercise those powers for the host chief constable. If, however, civilian officers are to exercise powers for the home chief constable in another constabulary's area, then that must be stated within the designation. That designation can be withdrawn at any time. If it is withdrawn, however, the person will still continue to be an employee of the police force and a member of police staff. Where that person has served for more than 2 years, of course, any consequent dismissal that may then arise would give rise to a right of unfair dismissal, or to claim unfair dismissal. It is at least arguable, in my view, that where a person is appointed as a police support officer, that the letter appointing them is at least capable of amounting to a designation. But if so, then either the letter must state what are their powers and duties which are conferred, or there must be in place some policy document or standing operating procedure that provides what are the powers or duties conferred, and that would have to be taken together with the letter of appointment. A failure to do that doesn't invalidate the appointment of the person as the police support officer, but it does mean that they are unable lawfully to exercise the powers of the constable that otherwise would be conferred. And recall also that any members of police staff who exercise the powers that are given to them in the designation must wear an identifiable uniform, and they must be able to present evidence of their designation on request. There is therefore the potential for increasing police numbers, either by way of police volunteers or by police staff, subject to 2 issues which I'll speak of briefly. The first is that ex-police officers could become police volunteers and be designated as police support volunteers with the same powers as police staff so designated. That would enable ex-officers to provide support to warranted officers or otherwise perform the functions that officers might have performed to free them up for other tasks. Furthermore, there seems to be no reason why ex-officers cannot potentially be sworn in as special constables. Be aware that whatever previous rank those officers held, there is only one rank of special constable, and that is special constable. I know that some special constables holding internal grades of, say, chief officer or special superintendent rank have suggested otherwise. My own view is that there is only one rank, and that is special constable. It also goes without saying that all special constables must be attested. A person who's appointed to be a constable but is not attested does not yet hold the office of constable. The office becomes held by virtue of the attestation. It's prohibited, or all of you will be aware it's prohibited, in the special constable regulations for the payment of special constables, save as relates to limited circumstances relating to expenses and potential loss of income. It is at least possible, and you may wish to have further consideration as to this and advice on this, for ex-officers to be recruited as police staff in the role of a police support officer, given training and then given designation as a police support officer, and then for them to be attested as a special constable. That would enable ex-officers to receive the pay of civilian staff members whilst being capable of deployment as a special constable. As you'll be aware, special constable will have powers that police support officer cannot have, such as the power of arrest. There are 2 elements to bear in mind with all of what I've just said. The first is that once a person is created as a special constable, they cannot be removed without statutory proceedings, either for gross misconduct or gross negligence, and gross negligence where either there's been a grossly negligent act or there's been a loss of service confidence whereby their security clearance is withdrawn. The second is a potential pension issue. You may be aware of the recent case of Corsham and the Police and Crime Commissioner for Essex, which was an appeal against a decision of the Pensions Ombudsman by several former police officers, some from Essex and the remainder from Avon and Somerset. Just to deal with that very briefly so that you are at least aware of the issue and may wish to take advice on it. In each case, a former police officer had retired after 30 years service under the age of 55 and then had been taken on by their former force as a member of police staff within a month of their retirement, under what are quite fantastically complicated provisions of the Finance Act 2004 that resulted in each officer being subject to a punitive tax liability on their pension sum. In none of those cases had the officers been employed, in each of those cases, the officers had been employed as police staff within 1 month of retiring, but it appeared that the punitive provisions would have applied whatever the nature of the work the officer was performing as a police staff member. I've myself spoken to counsel in that case, who said that the legislation which they looked indicated, in essence, that the same punitive tax treatment would apply if the officers had been engaged within 6 months of their retirement, where the employment was not materially different from their former duties as a police officer. And you can see that in the judgment at paragraph 102. The HMRC document said that there were 4 conditions which would give rise to such a situation. One was where there was a break in employment, which wasn't 6 months, and none was a break of at least 1 month where the re-employment was materially different. Those provisions only applied to officers who'd been retired and re-engaged whilst under the normal minimum pension age of 55. This talk is really for the purposes of training and discussion rather than legal advice, and certainly I'm not a tax lawyer and can't give you advice on those provisions. But what that does indicate is that there could potentially be tax liability for the officer concerned and the pension scheme if the officer is brought back, if an ex-officer is brought back into the force under normal minimum pension age at retirement, and where the gap between the retirement and the re-engagement is 6 months or less. So if forces are considering hiring officers as civilian officers, it might be worth your getting together to get advice from specialist tax counsel on the point, although I would have thought that although that's a complicated point for purely police officers, it should be straightforward for a fairly junior member of the tax bar to be able to advise upon it. But what we do is to flag up that as a potential issue. The final matter about which I'll speak and deal with briefly is the issue of safe system of work. You'll be aware that the general duties of an employer to all of their employees is to ensure that so far as reasonably practicable, they ensure the health, safety and welfare of all of their employees. Part of that includes the provision of personal protective equipment, which is at Regulation 4 of the PPE regulations. That provides at paragraph 1 that every employer shall ensure that suitable equipment is provided to his employees who may be exposed to a risk to their health and safety while at work, where and to the extent that such risk has been adequately controlled by other means which are equally or more effective. And second, in the matter that relates to the police, that where that would lead to inevitable conflict with the exercise of police powers or the performance of police duties, that requirement will be complied with only insofar as it is reasonably practicable. The obligation of the police force, therefore, in relation to your officers primarily is to arrange the methods of work or the organisation of the work so as to reduce the risk to your officers to the lowest possible level. If it's not possible to arrange methods of work so to do, then the obligation then arises to provide protective equipment. Once it's been determined that protective equipment is required, there needs to be an assessment as to whether it's suitable, and if it's suitable, there's then an obligation to provide it. There are the following steps in relation to assessing suitability. First, you have to assess and identify what is the risk of injury. Then you have to consider whether the equipment is, so far as practicable, effective to prevent the risk or to reduce it to its lowest possible level. And if the equipment is effective, you must then consider whether it is suitable for the purpose that's required. Those obligations will arise where there's a risk to health and safety whilst at work, where the risk is substantial, that means the risk is more than trivial. Once you have identified a risk, you have an obligation to assess it and to consider whether PPE is necessary, even if it transpires that the risk is so low that it wouldn't be reasonable to issue such personal protective equipment. The question as to whether such equipment would be disproportionate falls to be considered on the question of whether the PPE is appropriate. What that means is that forces will need to identify any new risks to which constables may be put, identify methods of work so as to reduce those risks to the lowest possible level, and if methods of work cannot adequately reduce the risk, then it will be necessary to consider the issuing of personal protective equipment, which must then be suitable for the purpose for which it's used. We'll consider that in some more detail and discuss it in some more detail in the questions to which we'll answer in a moment.